It had previously been the district's policy that any EPOs would go into a database, so, teachers and staff at the school would know about it, but the Selvies claim that wasn't done here. From there, the lawsuit states that they started to get reports on how much LS was struggling at school. Quote, on December 9th, 2025, LS's deaf hard of hearing specialist called Amber because LS was uncharacteristically struggling with her school assignments. When Amber informed the specialist about Butler and the EPO, the specialist had no idea what Amber was talking about. Okay, so now you're talking about a potentially important witness at a trial. Amber complained to Assistant Principal Grant about the staff not being informed of LS's situation. Grant responded by emailing LS's teachers to give grace on missing work because LS was having a, quote, rough go of it. On January 14th, 2025, Walter Howell, that's the school principal, called Amber Selvey regarding Amber's complaints with how the school was handling LS's situation. Howell informed Amber that he chose not to enter the EPO into the school's database because he did not want to interfere with Butler's opportunity to receive an education at defendant school district. Wow. Horrifying if true, and also very important for a legal context because, as we'll talk about later with the causes of action, you can show two students were treated differently, if you can show preferential treatment, or if you can show disparate treatment, right, of a student, that's key. So the lawsuit claims that the situation just continues to devolve, with the school's resource officer, that SRO, deciding to get personally involved. Quote, January 22nd, 2025, SRO Blankenship pulled LS out of class for a private meeting, which is against school policy. At the meeting, SRO Blankenship informed LS that he was aware of Butler's habit of stalking LS in the school parking lot. SRO Blankenship informed LS that as long as Butler did not speak to her, SRO Blankenship would not do anything about Butler's conduct. Upon information and belief, SRO Blankenship deliberately pulled LS out of class and then escorted her back to class to embarrass her. According to the court file, the safety plan was held in January of 2025 regarding LS. And the thing about that is, the allegation is, only members of the safety team were supposed to be there, but the lawsuit claims that Principal Howell came in anyway, leaving the door open so that people outside the room could hear what was going on. Meantime, Blankenship, the SRO, the resource officer, was required to be there as part of his job, but the complaint says he never showed up. So the safety plan that ended up being put together then allegedly wasn't shared with teachers and staff. So the Selvies tried to go over the SRO's head to no effect. They claimed, quote, on January 30th, 2025, Tyler and Amber Selvey complained about SRO Blankenship's conduct to his supervisor and a Cluck at the Stillwater Police Department. After listening to the Selvies' complaints, Lieutenant Cluck told the Selvies that SRO Blankenship is friends with the Butlers, so they should not hold SRO Blankenship's conduct against him. Then from there, LS and her family claimed that Butler violated the EPO. Now, during an alleged incident in February, the complaint states, quote, student athletes were on the basketball court for a school-sponsored event, senior signing day. SRO Blankenship was in attendance, as were multiple members of the administration and staff were present. At senior signing day, in full view of staff and administrators, Butler came within 5 feet of LS to stare at, harass, and intimidate her. Not one school employee intervened on LS's behalf in response to Butler's violation of the EPO. It was only when one of LS's cheer teammates informed the cheer coach about Butler's conduct that anyone intervened. The cheer coach removed LS, not Butler, from the court. So look, Butler was arrested. He was released on bond in March of 2025. We know that. But according to the lawsuit, it wasn't until August 4th, 2025 that, quote, defendant school district finally informed LS that Butler would not be allowed on campus for any reason. But according to this complaint, the alleged harassment campaign reportedly continued. Quote, during this fall semester of 2025, Walter Howell continues to attend football games where LS is cheering and he repeatedly stares at and harasses LS and her family. Now again, as we went all through that, and I'm going to go through the causes of action, these are allegations, right? This is part of the complaint. These are allegations. A lot of this is based upon information and belief. So the idea is, look, this is what we think we know right now, based on what we see. It will obviously have to be more fully fleshed out and corroborated through the discovery process, through leading up to trial, testimony, but now we got to get into the causes of action, okay? As part of the lawsuit, the Selvies have listed 9 claims for relief. I want to go through them. So the first accuses the school district of violating Title IX. Title IX states in part that, quote, no person shall on the basis of sex be excluded from participation in, be denied the benefit of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. The lawsuit states the abuse, harassment, and discrimination suffered by LS was so severe, pervasive, and objectively offensive that it deprived her access to the educational benefits and opportunities provided by the school. So you're alleging here a pattern, right? That the school district had knowledge of Butler's harassment and abuse, and that she was retaliated against. There was an allegation here that they failed to investigate Butler. They didn't stop him from harassing and intimidating, that they didn't enforce the EPO, that they banned LS from attending baseball games so Butler could still play, really suggesting disparate treatment, like I mentioned before. The second claim for relief is also against the district, violation of equal protection under 42 U.S.C. Section 1983. Quote, after LS reported Butler's sexual assault and harassment, defendant school district acted with deliberate indifference to her rights. So the idea here, protecting Butler at Ellis's expense. How the school district allegedly allowed a pattern of harassment and intimidation. The third claim is filed on behalf of LS against Jesse Butler, Mac Butler, Walter Howell, and Paul Blankenship, the SRO, for intentional infliction of emotional distress. Quote, defendants' actions in the setting in which they occurred were so extreme and outrageous as to go beyond all possible bounds of decency and would be considered atrocious and utterly intolerable in a civilized society. This is a very broad claim. You're talking about intentionally or recklessly causing severe emotional distress. The fourth claim is what's called respondeat superior, which holds employer liable for the actions of its employees. Quote, defendants Mac Butler, Walter Howell, and Paul Blankenship were acting within the scope of their employment when they intentionally inflicted emotional distress on LS. Defendant school district and city are directly liable for the actions of their employees while in the scope of their employment. So you really have to show that what the individual players did, what they allegedly did, was while they were working or they were carrying out their official duties, and they weren't doing something, independent while off duty. Fifth, so this is against the school district and the city of Stillwater. You have negligent hiring, supervision and retention, and gross negligence. When you talk about negligence, duty, breach of duty, a harm suffered, and that breach caused the harm that was suffered. Now, gross negligence is an extreme deviation from the standard of care that was owed here. Really disregarding the risks, the consequences of a certain course of action. So here it says, quote, defendants negligently breached their duties to LS by hiring, failing to supervise, and or retaining Mac Butler, Walter Howell, and SRO Blankenship by allowing defendants to harass, embarrass, and intimidate LS in the course of performing their work. The sixth claim accuses Mac and Jackie Butler of negligence, quote, on information and belief. Mac and Jackie Butler were aware of Butler sexually assaulting LS and could have prevented it. So namely, they knew their son sexually assaulted LS. They didn't intervene. You really have to show that they knew or had reason to know of what was going on. That's how you can potentially hold parents liable for the actions of their child. And then the seventh and eighth claims are for battery and assault. They're on behalf of LS against Jesse Butler. So for battery, you have Butler, quote, acted with the intent to make harmful contact when he sexually assaulted LS and strangled her. For assault, quote, plaintiff LS was placed in apprehension of immediate harmful contact as a result of Butler's conduct and suffered fright and terror. So that's stalking, intimidation, harassment. Now, I believe in Oklahoma, no contest pleas can't be used as admissions of guilt in a civil case. So LS's lawyers can't say, look, Butler admitted to doing all this. Clearly, he should be found liable for assault and battery. But obviously, that investigation, that evidence, that can overlap and come in a civil case and potentially would be strong in proving claims like this. But the final claim is on behalf of LS's parents against all the defendants for negligence. Quote, as a direct and proximate result of the foregoing, plaintiffs Amber and Tyler Selvey were deprived of the comfort, enjoyment, and society of LS. So in certain cases, a family member can be hurt by the injuries that are suffered by a victim. What did they lose? Now, I should say that the family has not named a dollar amount of what they're seeking in the lawsuit, but the Selveys do claim that they're owed at least $75,000 in damages. That's how you get to the federal case threshold as well. This legal fight, by the way, I should tell you, doesn't end here, because you also have something else going on. You have a victim's rights attorney who has also filed a motion with the state court claiming that her client's rights were violated under Marcy's law. We talked about this in a previous sidebar, because the claim is she wasn't properly consulted or heard before that controversial plea was struck with Jesse Butler. In fact, I spoke with attorney Rachel Bussett on December 15th.
So Marcy's Law is a crime victim's bill of rights, and it was passed into the Oklahoma Constitution in 2018, supplemented by statutory definitions and processes that are supposed to be given to victims. Along the way, if you read through the statement of facts and procedural history in the case, you'll see that there were a number of times where my clients weren't given proper notice. They didn't follow simple procedural aspects of what we're supposed to do as lawyers. There were other times where they were given partial information or no information at all, or the information that they were given was given in such a way that they didn't have a meaningful time to process it, work through it, and understand it. So there are different things that happen at different times.
And is the goal for Jesse Butler to ultimately be resentenced, for the youthful offender status to be stripped away, for him to be sentenced as an adult, for him to get prison time? Is that something, or is it at the very least for your client, her family, to be heard, to just be heard in a courtroom? What is the outcome that you're looking for at this point?
We're looking for an outcome that holds him accountable. And I know there are going to be people that say, well, this does hold him accountable as a youthful offender. But the biggest thing is he hasn't admitted what he's done. For the Youthful Offender Act to work the way that it's supposed to act, there has to be a taking of responsibility. And he hasn't taken any responsibility here. So we need some sort of admission of responsibility at a minimum.
Now, so far, the Butler family, the school district, the city of Stillwater, they have not responded to the federal lawsuit, but we'll definitely keep a careful eye on this. That's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. You can follow me on X or Instagram. I'm Jesse Weber. I'll speak to you next time.
Convoy's down. Take whatever you can use.
What is that?
Guild has charging stations nearby. Take them offline and disrupt their ops.
Accessing reactor chamber.
Frag sent. Oh.
There's a quarantined command center nearby. Stop the toxin from getting out. I'm picking up something weird. Toxin levels high. This could get crazy. It's down. Wonder what you saw out there.
Black box located.
Connect your C-Link, and I'll pull the data. You've got a guild helo coming in. Dropping off reinforcements.
Grenade going out.
You've got a guild helo coming in. Data came through. Network located. Use network.
Enemy grenade.
Moving behind me.
Rally on marked coords.
Exfil's on the way. Hang tight and keep the LZ clear. LZ's too hot for the VTOL to land.
Designating codes for LVTR.
VTOL can't land with whatever the hell's down there.
Lobbing frag.
VTOL touching down. Move it or lose it. VTOL's RTB.